Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now. It's good to see you joining today, and I'm happy to be back today. I do have some information for you today because I've gotten a number of calls on this topic, and I want to make sure that you understand how serious it is to face this type of issues and ways that you can resolve it. So I can't wait to talk to you about this today. But go in the meantime, go ahead and put your questions in the comments so I can answer your questions as well. So as soon as I'm finished talking about the topic, we can jump straight into your questions. And it can be anything that's immigration related. And then hi there on Instagram. It's so nice to see you. Hi on YouTube, Facebook, Twitch. Nice to see you. And hello on TikTok. Thanks for joining me. All right. So, what if your US citizen or legal permanent resident spouse is using divorce as a pawn? So, when I say they're using divorce as a pawn, they constantly threaten to divorce you. But they do this in such a way that they usually threaten to divorce you when maybe you're not complying with something they want you to comply with. Maybe you are empowering yourself in certain ways. They want to make sure they can take away that power from you. Maybe you're here without your papers already, and in this context, in immigration context, that's usually the case where you may be here without your papers, and you are married to a U.S. resident, permanent resident, or a U.S. citizen, and they feel as if they have that power over you. And as a result of that, they constantly threaten you with divorce. And the idea behind that threat is that if they divorce you, you're done. You're done with your immigration. You're going to get deported, or you're going to be in a lot of problems. There's going to be no way for you to fix your papers if they divorce you. And I want to empower you today because I feel like there are so many people who are living here in the United States under these kinds of conditions. And it is what leads to trafficking, and it leads to people being trapped in situations they don't want to be in. Usually, the spouse or the significant other will use this threat of divorce or breaking up to make you feel as if you have to do what they say, or else, right? And I'm here to tell you, especially if you're married to a U.S. citizen or a legal permanent resident, if they're using divorce as a pawn, that means it's a tool for emotionally abusing you. Because when they threaten divorce like this, that's cruel. That does fall under extreme cruelty. And they're using it to hold your immigration status over your head. They're using it as a way to hurt you. Their intention is to hurt you. And when they're doing that to you, it means that you qualify for VAWA. A lot of people don't realize that even threatening divorce, using it as a pawn against you, is a form of emotional abuse, and it qualifies you here because that's a loaded statement. Whenever they're coming, I can understand in some situations where as couples, as a married couple, maybe the divorce word gets thrown out um, once every blue moon because of a conflict. But it's never going to be a pattern. The minute that the word divorce, and it's always one sided, where one person is always threatening divorce, the minute it's being thrown out there constantly, usually triggered by your resistance, your lack of compliance, it's that means that it's a form of extreme cruelty at a minimum and emotional abuse. So, if you're in a situation like this, just know that it cannot be used as a weapon against you. If this person wants to take themselves and go divorce you, what you need to do is look out for yourself at that point and make sure you get your paperwork in and empower yourself. That's how you're going to protect yourself. You can tell them to go ahead and do whatever they need to do to make themselves feel happy, and you can escape that situation as well, and that's going to be through VAWA. So that does qualify you here. The VAWA process, and let me tell you why it's important. The VAWA is important. Submitting a VAWA petition is very important here. So you have a spouse who is using divorce as a pawn, and along with the threat of divorce comes a lot of other threats behind it, right? It means that if they divorce you, you're vulnerable. You may not have your immigration status. How are you going to get your papers now? Because they've threatened, they're going to divorce you. You might get deported. Along with the divorce, they might call immigration on you. They may tell immigration that you're illegal. They may, and by the way, when I say illegal, this is just a common terminology. I do not believe people are illegal, but it's a common terminology that an abusive spouse would use. But say they say that to you, and so you are constantly in fear of the consequences here. Now, what you should know is that you can apply for VAWA, and the minute you put your papers in for a VAWA, you're in a protected status. It means now you have confidentiality. So immigration cannot disclose this information, your information, to any outside parties. Now, if you don't have VAWA pending, then immigration can always investigate, call the spouse, disclose to the spouse, hear the complaints of the spouse or the claims of the spouse, and then use it against you. I've seen it happen, right? Especially when you're already going through the process with a spouse you don't trust. And that spouse then uses immigration as a weapon against you, and they tell the immigration all sorts of lies. Immigration tends to defer to what the spouse is saying, by the way. So that's another reason you should think twice about going through the immigration process with a spouse who's mistreating you, or a spouse who is threatening to sabotage you, or you do not trust. Because I have seen this where they go to the final interview, and the minute something comes out of that spouse's mouth that says something like, I was just helping her out for the green card, she just married me for the green card, their ears tend to perk up, and they tend to believe they tend to defer to the US citizens' claims in order to find that you are not eligible, and in worst case scenario, you committed marriage fraud, which is the worst case scenario that you can have. So with this, when you choose to pursue this option on your own, it means that with VAWA, they cannot disclose any of the information. They can only look at what is in the file. What information did you provide to them? They can't take calls from the spouse. They can't take up the phone and call the spouse. They can't call third parties. They don't even contact the police, right? The idea of this is to see whether you qualify for relief to get away from this abusive situation. It is not to investigate anybody or get anybody into trouble. And a part of the confidentiality is that they can't call any outside agencies and disclose this or corroborate that information. Actually, it comes with penalties against the officers that do this. So if an officer does violate the law and does this, it does come with penalties. So they take it very seriously. They take it so seriously that when I do represent my clients, I am the point of contact for my clients. and then I get to give them the correspondence from the USCIS, because they are not into sending your mail all over the place and then finding out that a third party found out about your VAWA petition. Now, the other benefit of this is, why are you protected? Why is it important to get this in? Is because once it is in, if, say, the spouse calls and frames you and says you only married them for the green card, they cannot put that on the record against you. They cannot add it to the VAWA file. The officer cannot use it as a deciding factor in your VAWA petition. They cannot, unless they can independently determine that there was marriage fraud. The officer has to independently determine based on their own evidence. They cannot take the information from the abusive relative in a VAWA case. So they cannot take it from the spouse here. So what that means is that you are in a protected situation where you are not going to have to worry about the threats or the threatening calls of an abusive spouse, and one that is putting you through emotional abuse, like constantly threatening to divorce you, or constantly threatening to leave you. That, while I know it's hurtful and they are your spouse, it's going to be hurtful and maybe even hard to walk away from the situation. But you know that when you pursue the VAWA option, you can move forward with your life, and you can take time to heal without the added stress of wondering, what is the spouse going to do to sabotage your process? And what I say is, don't even tell the spouse, and don't tell anybody associated with the spouse that you're applying for the VAWA, because this just avoids any complications in your application process. So that's what I wanted to talk to you today about. Just wanted to, if you're going through a situation like this, just know that there is power in filing your immigration papers. It's confidential, and you can walk away from the even though it's a hurtful situation, you can walk away from this situation and empower yourself, and eventually recover from this abuse and mistreatment. All right. So now I'm going to jump into questions. Go ahead and put your questions in the comments right now, because I'm scrolling through. So put those questions in the comments. Okay, so I have a final hearing for asylum. Go ahead, give us a call. Let us talk about what's going on, and let's see if we can help you. No, don't wait till last minute. You need to make sure whenever you have a final hearing for asylum, you need to make sure it takes for us, while we look at each client's case, individually, to figure out what we need to do to prepare. It takes us at least a year before the individual final hearing to make sure we're ready for it, right? It takes us a year of preparing, because there are a number of very important steps that we have to take. There is legal research. There's submitting briefs and legal arguments. There's also getting witnesses if we need witnesses. There's retaining additional evidence or corroborative evidence of the persecution. Expert witnesses may need to be involved, depending on what type of case it is. So it's not just about showing up at a final hearing. To have the best ability to succeed here, it does take preparation and investment. So get in touch with us. If you've been approved T status, then you want to apply for your green card. Would that be a 10-year? So once you get a green card, it will be a 10-year green card. It won't be conditional. Can an F1 who is billed to graduate in May start processing the green card? So it's gonna depend on now. let me just make this clear. Having a student visa and graduating is not by itself going to qualify you for the green card. You have to qualify in other ways, either through an employer or through a spouse. Those are the fastest ways. Or through a parent if you're under 21, or an adult child who's age 21 and over and they're a US citizen. Those are the fastest ways. Anything else is going to take some time, and you have to make sure you're maintaining your legal status to continue. So, you, for example, if you graduate on F1, you may have OPT for a year afterwards, and maybe that might give you enough time to apply if you're going through an immediate relative, meaning a US citizen and you're an immediate relative, or through an employer. So, this is where it's so important to get legal advice, because you want to make sure that one, you do qualify. I have seen people being scammed, and it's really a terrible situation to see somebody who has a lot to look forward to graduating from school, and then losing their status because they were scammed. So make sure you get legal advice to understand your next steps. If I've already self-filed, can you be my representative and file a G28 on my behalf? I already received work permit and social. So it's going to be hard to determine whether I can accept your case unless we talk in a consultation. That's where I determine whether I can take your case, whether you qualify for the benefit that you've self-filed for. So I think sounds like you're a self-petitioner, maybe for VAWA, but it's going to depend here. And we can have a conversation. I need to understand though what's going on. Do you have to wait to become approved for VAWA to apply for the work permit? No. Now it depends. But for the most part, if you're waiting for your priority date to become current, if your priority date is years long, then you may need to wait until the VAWA petition is approved for you to get the work permit associated with the approved VAWA. However, if you qualify to apply for adjustment of status at the same time that you're applying for VAWA, you do not have to wait for the VAWA to be approved. You can apply for the work permit at the same time as you're filing the VAWA petition. Now, usually the individuals who do qualify in this way, where they can apply for the work permit at the same time that they're applying for a VAWA, is if you are the immediate relative of a US citizen. That means you're the spouse of a US citizen, or the spouse of a US citizen, the parent of a US citizen who's age 21 or older, or you're the son or daughter of a US citizen you're under 21. If you fall outside of this category, your priority date has to show as current on the visa bulletin for you to be able to apply for adjustment of status at the same time. So it does take some verifying if you're outside of that category of immediate relatives of a US citizen at this time. Can an F1 answered that. After receiving SSN and work permit, can I still file for abandonment or VAWA? Yes, and actually it's so important. This is urgent. Your case is urgent because what it's telling me is you're currently going through the marriage-based adjustment of status right now. You've gotten your work permit and you've gotten your social security number. However, they're no longer available because they've either mistreated you through abandonment or they've mistreated you in other ways. And applying for VAWA now means you preserve your SSN and your work permit. Because when you apply for VAWA, you can switch over your adjustment of status process to the VAWA process. But as long as you're just waiting out the process, you're not taking any action. Eventually, if they call you to the interview, the spouse doesn't show up or you don't reply to a request for evidence, they deny everything, and that means your work permit, SSN, everything gets canceled and you have to start all over again. So your case is urgent. If you need to look out for yourself, apply for VAWA, make sure you first meet the qualifications and then get moving on that. I do assist my clients with the process, so get in touch, schedule an appointment, and let's talk. My schedule is filling up, So please act fast so I can help you. How long after getting I-485 receipt notice is a green card in the mail? So how long after getting the I-485 receipt notice? So if this is the approval notice, then you're looking at about 1 to 2 weeks before you get to see the green card in the mail. But if you're talking about as in you just filed the I-485, then I would say 8 months to 12 months to get the green card eventually. And you may still have to do an interview, you may not. Does the same relate to T status? Oh, I'm sorry, I've lost track of what the previous question was. So I'm not sure what the same is applying to. So just repeat the question for me so I can understand what context you're referring to. I just tried to call about a situation I had. So the staff scheduling coordinators will call you right back. If you, and sometimes the phone lines do get busy, just make sure that you go ahead and still talk to the receptionist who answers. They will still assist you, take your details, and then the scheduling coordinators who are in charge of my calendar, getting you on my calendar, will definitely work with you to get that done. So just make sure to leave your information and we'll get right back in touch with you. And that's when the phone lines are busy. If you stay 1 day over 6 months in the United States, can this deny your immigrant visa during 2020 pandemic? No flight in and out, but can show ticket flight cancellation. Unfortunately, yes. So that no, if 1 day over, okay. So in this case, you're 1 day over the time you were permitted to stay. No, that does not lead to an inadmissibility. What leads to a 3-year bar is going to be if you spend 6 months out in the United States without status. The minute your visa expired or your stay expired and you continue to stay here in the U.S., they every day is going to count. When it gets to 180 days, that's when you have to be worried about that 3-year bar. Now, are they going to deny the immigrant visa because of a 1 day stay over the visa date? They should not. Does not make you barred. It does not make you inadmissible. And an immigrant visa is different from a visitor's visa. If it was your visitor's visa you were applying for, then yes. But since this is an immigrant visa, which leads to the green card, they're not going to look at that. They should not be looking at that. How long after applying for VAWA? So I answered that. Can an F1 student start filing for work permit? No. So F1 students are limited, and for usually in the first year they cannot work. In the second year they can work on a very limited basis. So you have to get a legal consultation just for us to understand your situation. If I had got divorced, can I still get my green card? And I only got one hearing for asylum case. So it depends. I'm glad that you brought this up. Now, if the spouse threatens to divorce you, you say, sure, go ahead, be my guest, go ahead and file those divorce papers. After the divorce is finalized, you have 2 years to apply for VAWA. So if it passes 2 years, you're not allowed to apply for VAWA anymore. How long after applying for VAWA does it take to receive work authorization? So 8 months to 12 months. Does USCIS deliver notices, etc., to PO box addresses? So some of my clients, they have received at the PO box. But please make sure you verify directly with the USCIS. I'm not telling you to give PO box addresses. Verify with the USCIS that that's an address they can deliver to. Make sure you also talk to the whoever has the PO box. How long after having a case with courts can you apply for citizenship. So if it's a criminal issue, it depends on what kind of criminal issue you have. And I don't know what kind of case. You didn't say criminal, but I'm assuming that's usually the only thing that would prevent you from getting citizenship if you had court. Get legal advice. I got approved email from NVC for I-130 April last year. How long before I get a date? So I'm seeing about a year and a half. So you help green card holders get, oh, yes. So this person, Johnny says, is asking if you help green card holders to get their citizenship. Is one of my favorite things to do, because it's usually the final step. Actually, just last week, I was at the USCIS West Palm Beach with my client. And what I'm saying now is the time, guys, to get citizenship. Everybody that was there that day that got approved became citizens on the spot, including my client. So my client went through the interview, answered the questions, passed the test, and then the officer just said, "Okay, stand up, take the oath. You're now a U.S. citizen." So if we didn't have to wait for any swearing in ceremony, it happened right there in the officer's office. And this was happening in the office for the 2 hours that I was there. They were rolling all of them into the room to get their naturalization certificate on the spot. They didn't mail anything to them. They got their naturalization certificate on the spot, handed back their green card on the spot. So absolutely, I do, and I'm telling you this, it's a good time to apply for citizenship. Remember, during the previous administration, it was taking a year and a half for people to get citizenship. That rate of denial was a lot higher for citizenship. However, even though you still do have to meet the requirements, they are really pushing these through quicker than any other application types. So I'm seeing them in 2 months. I've seen them in as short as 2 months. Average is about 5 months, 5 to 8 months for my clients to get citizenship. So don't wait. Now is the time. Do not procrastinate on this. You could be going into the USCIS office for the interview, coming out a US citizen. So, and I did see it, and this has happened multiple times with my clients now who have gone from permanent resident to citizen. All right. A family member has been living here for almost 6 years. She applied for VAWA almost 3 years and is awaiting final the green card. How long can she wait to apply for citizenship after the green card? Through Now, if she applied for VAWA based on her U.S. citizen spouse, then 3 years. Do you think because I was out of status for 2 years, then get married, is that the reason why USA has taken 16 months? Because they approved your I-130. So I'm not sure why. It's hard to say why it's taking that long. Sometimes it's an additional background check. Usually it's not because you were out of status. Most 99% of my clients are out of status at the time that they're applying, and they still get it within the 8 to 12-month period. What evidence do you need to file I-751 solo for extreme cruelty? So it's going to depend on what evidence you have and what kind of extreme cruelty did you experience. At a minimum, we do help our clients to submit a declaration. That's their detailed statement, along with any other evidence, text messages, emails, transcribed phone calls, pictures, anything else, along with witness statements that can show that you were the subject of extreme cruelty. I'm a US citizen and my spouse is on F1 visa. We have not applied for green card yet. Can she travel outside of the US at this point? I heard opinions of being denied entry to the US upon arrival. So it's hard to say Yeah, there's always going to be a risk, especially if they believe that the person with the visa now has immigrant intent. So, yes, it does happen, but it's going to depend on the factors here. If there's something you are particularly worried about, that's where it's important for you to schedule an appointment. Can I apply for VAWA from my 24 US child because I entered without inspection 28 years ago? Absolutely, yes. You can apply for VAWA even if you enter the country without permission. Hey, my interview has been waived. Do you know how long it will take for me to get the green card? So it depends. If you got the approval notice, about 2 to 4 weeks. How long does it take to get your green card? When the I-45 is sent with the I-360. From filing to green card, about 3 years, but you do get a 5-year work permit right now and a travel document if you apply for the travel document, about 8 months to 12 months, which will hold you over until you can get the green card. I'm doing a VAWA. I got the receipt for work permit. How long will that be? About 8 months to 12 months, as long as it's done properly. What's the difference when it comes to VAWA, spouses, LPR, or citizen? LPR right now was not before July. We didn't have this, but now there is a wait list for spouses of legal permanent residents. To get on the wait list, you still have to apply for the VAWA petition, but it's a two-step process. So you have to wait until you get to the top of the wait list to apply for your adjustment of status, work permit, and travel document. With you being the spouse of a U.S. citizen right now, that does not count. There's no wait list, so you can apply for all of that at the same time. So that's what's going on right now. My husband got his I-130 approved January 2nd. That's good news. It means that now if they're here in the US, got it approved, it means that the next step is possibly the green card. The interview is going to be waived. My mom is a green card holder and she sponsored for us. My I-130 has been approved. So the I-130 has been approved. Now you have to wait for your immigrant visa number to become current. So be very careful with this process. Make sure you're getting legal representation through the process. What's next after getting the work permit? If you're going through adjustment of status, hopefully the green card. All right, that's going to be it for me. Thanks so much for your time, everyone. I am going to work to be back tomorrow. So go ahead and join me tomorrow with your questions again. Thanks so much. Have a good one. Bye-bye.